Welcome to the MacMillan Report. I'm Marilyn Wilkes, your host, and our guest is Lawrence Liang, a legal researcher and lawyer based in Bangalore, India, known for his legal campaigns on issues of public concern. He is here at Yale as the Rice Visiting Fellow in the South Asian Studies Council at the MacMillan Center. His key areas of interest are law, popular culture, and piracy. Professor Liang has been working closely with the Sarai program at the Center for the Study of Developing Societies in Delhi on a joint research project on intellectual property. Today we talk with him about the recent ruling on the Delhi University photocopy case. Welcome, Professor Liang.
Thanks, Marilyn. Pleasure to be here.
So let's begin with an overview of the photocopy case. Tell us about it.
Well, what happened was around 4 years ago, some of the leading academic publishers, Oxford, Cambridge, Francis and Taylor, filed a copyright infringement case against a small photocopying shop at Delhi University, along with Delhi University. And this was about course packs. So typically, for the graduate level, a lot of the courses are designed using extracts from different books. And the publishers claimed that this was a violation of copyright. We filed an intervention on behalf of the students and on behalf of the teachers, arguing that this was actually legally permissible in the law. And I think the importance of the issue was that this was a test case, both for India but also for other developing countries, on what the extent of the fair use exception in copyright law would be to facilitate access to knowledge in a situation where learning materials are extremely expensive. And in a country as sharply divided as India is, this can mean a great impact on the ability for students to access learning materials.
Do you think there's a reason the publishers chose this particular photocopy shop in India versus, something in another part of the world, for instance?
Well, absolutely. I mean, a number of reasons for that. One was that the photocopy shop is located within the university. They had a contract with the university, and they were in fact given library cards which will allow them to take books before the start of term to create these course packs. The second is that, in a way, that the efficiency of the photocopying shop, where it became the most popular kind of to-go-to place for people and for students to access material. You have to remember that in many libraries in India, you have either a single copy of a book, or in many instances, you don't even have a copy of the book. So come exam time, a lot of students rely on being able to get these books through photocopy shops like this one.
Okay, so what was the crux of the case?
The crux of the case was that there is an exception in copyright law in India which allows for the reproduction of the work for educational purposes. And it literally says reproduction of the work in the course of instruction. The publishers wanted a narrow reading of this to mean literally giving a copy to a student in class and taking it back from them. Whereas we were arguing that obviously that cannot be the interpretation, and it had to be on a much wider terrain. The second big issue was the question of how much you could copy. So as you know, in the US, over a series of cases over the decades, they've laid down a quantitative restriction of 10% of a book being permissible for education.
That's interesting. I did not know that, actually.
Right.
I would have said it was much greater than that.
Right. So that's, in fact, the precise question. The question is that for a country like US, where the infrastructure of education is already very well established, if you have a rule of 10%, then the question is, would that be adequate for a country like India? Should you have a differential standard for developing countries on education? And that's why it's an important case for the rest of the world, because in a way, the globalization of intellectual property, and it is the global regime, has also been accompanied in a way by the use of standards from cases primarily from the US. And it's very rare that you actually have cases from developing countries that lay out a kind of different philosophical premise on how we understand copyright law.
Okay. What was, I believe his name was Justice Endlaws, what was his actual ruling?
So Justice Endlaw concluded with the claim that there was no prima facie infringement claim that had been made. The reason being that if copyright is a right that's granted by statute, it's also accompanied by exceptions. Copyright, you must remember, began as a law that wanted to facilitate public access. So the very first copyright statute, the Statute of Anne, is entitled a law for the advancement of learning. But over the decades, copyright has primarily become about the protection of the rights of private interests and about the rights, in a way, of the owners of copyright. So I think it's in in the manner of maintaining a balance between public interests and access to learning material and promoting creativity, while at the same time ensuring that there are some incentives for creators of works. So what Justice Endlaw did was that he brought this balance together to say that in the case of education, there is a policy kind of a premise which informs why there is an exception carved out for education, and that does not interfere with the legitimate interests of the publishers. And if that is the case, then there can be no claim that there was an infringement for making of course packs.
Okay, and do you think that, okay, was this solely, his argument based solely on educational institutions? For instance, if I'm a private citizen and I want to photocopy, a book and give it to my sister, for instance, will that fall under this ruling or no?
So one major difference between the US and India in terms of the structure of copyright law is that in the US you don't have enumerated exceptions. What you have are general principles. So there are 4 principles that would determine whether the use of a work is fair or not. But in the Indian context, you actually have enumerated exceptions. So there are other exceptions for private use, but that's primarily for research. So if you wanted to, let's say, photocopy J.K. Rowling's Harry Potter books and give it to someone, that would not fall within fairness. The provision that we were arguing for was specifically about educational uses. So the question is, assuming I wanted to, in an English literature course, photocopy 2 chapters of Rowling's Harry Potter, would that be allowed? And the answer was absolutely.
Okay, and you say we. Did you actually work on this case yourself?
Yes, I mean, we were part of a team that consisted of a number of lawyers advising the students and teachers, even though they were not a party to the case. Our argument was that this is a case that's about the future of education, and it cannot be fought without the voice of students and teachers being heard. One of the ironies of the case is that the petitioners, the publishers, cited the use of textbooks and academic books by a number of academics. These academics signed on the case to say that we do not have a problem with students using our material for courses.
Okay, and what do you think the implications of this ruling will be, not only for India now, but also more globally?
I think one of the key challenges in terms of global copyright and the access to education movement has been the question of how do you balance between, on the one hand, your obligations under international law, because all countries are a signatory to the TRIPS agreement, which lays out a common minimum standard in copyright. But at the same time, because the needs of every country is unique and their developmental challenges are extremely, in a way, individual, how do you balance between your legal obligation versus the flexibilities that you can use as a country? And I think what this case lays down is a very good precedent for other countries to follow, especially from a developing country's perspective, on how you can interpret your laws even while remaining compliant with international standards.
Okay, and in terms of the publishers themselves, I'm not familiar actually with the legal system in India. Can the publishers appeal or no?
Well, unfortunately, the publishers have already appealed.
Okay, so you
we
can't,
urged
have that
them,
right.
once the decision came out, a number of intellectuals, including the Nobel Prize winner Amartya Sen, when the case had been filed, had written to them as authors with Oxford, urging the publishers not to take this kind of agonistic stance.
Right.
Over the course of the last 4 years, in a way, they've already alienated a number of students, a number of academics. And so when the judgment came out, a number of us who had written after the judgment urged the publishers not to appeal. And we were trying to make the case that students and teachers are not your greatest enemies. They're your greatest allies. So you have to think in a way of how you were to create and think about a business model that ensures that it's feasible for you, even while at the same time not impeding access to knowledge. Unfortunately, the publishers haven't heeded our call, and they filed an appeal.
Right.
So we will have to take this all the way to the Supreme Court.
Okay.
So.
Do you think that these publishers, have you heard of any instances of these publishers starting the same, I'll call it trouble in other developing parts of the world?
I think it's important here to remember that the Indian market is a particularly lucrative one, both in terms of the size of the students, but also because it's the primary language of education at the university level is English. So in a way, this is one of the most important markets for the academic publishers, which is, I think, why they wanted to use this as a test case.
Right,
So
right.
this has, of course, happened in developed countries, and in the US, this has been happening for many, many decades. But in terms of the developing countries, this is one of the first major cases.
Okay. And in terms of the appeal, what do you think the outcome will be?
Well, we are hopeful because the judgment is a very sound one, and it's kind of very solid in its interpretation of the law. That we're hopeful that this will be, it will not be overturned on appeal.
Right, right. How long has the process been in terms of, the beginning of the case, and then how long will the appeal take?
The case was initiated 4 years ago. So between the initiation of the case to the judgment at the High Court level, it's been 4 years. They've appealed now to what is known as a division bench, which is a larger bench within the High Court. And assuming it goes our way, then they may appeal to the Supreme Court, and vice versa if it goes against us. But in a way, this is a part of a much larger movement that's been taking place for the last 20 years. And Yale has had a very important role to play in that, because the Yale Law School, which is very active on debates on intellectual property from a global perspective, has been crucial in anchoring an access to knowledge movement. So I think that this is seen and followed by the global community of people working on intellectual property from a public interest perspective.
Right, right. So it's I think it's wonderful that you've kind of almost come full circle with Yale having started it, and you working on this case in India and being here with us today.
No, it's absolutely fortuitous.
Yeah,
And we hope that this collaboration will continue, because this debate is not going to end with this case.
Right, right. Okay. Well, thank you very much for being here with us today and sharing some of your work.
Thanks, Marilyn.
For more information about Professor Liang and his research, please visit our website at macmillanreport.yale.edu. Be sure to join us again for another episode of the MacMillan Report, made possible through funding from the Whitney and Betty MacMillan Center for International and Area Studies at Yale.